Hello and welcome to hashtag IP series with Rita. So Rita is actually spelled as R-E-E-T-A-H. That's a nickname my friend Beverly gave to me. But yeah, I'm your host, Rita Chinda. And for my first time listeners, thank you so much for tuning into my podcast. If you're a returning listener, thank you for always coming back to listen to my podcast that features conversations on recent cases and development globally. This will take the form of copyright, trademark, patent, industrial design, trade secret, plant varieties, and geographical indication. Please don't forget to favorite my podcast, don't forget to subscribe, and also like and share. If you want us to talk about any recent case or you would love to be featured on my podcast, please send me a message or at ipseriesinfo@gmail.com. So on today's episode, we will be celebrating the Fashion Law Day. Remember, IP basically interfaces with every sector. So trust me, if you're a fashion designer, a fashion illustrator, you work in the fashion business, this topic is going to be of immense importance to you. So I hope you guys enjoy listening to it as much as you enjoy reading it on Twitter. Sorry guys. But yeah, let's get right into today's topic. Okay, so a little backstory on how I got to, talk about this. So I came across a story about Pretty Little Thing and Hanifa. Sometime I think February or March, and I was like, "Ooh, this looks interesting." And then few weeks down the line, another story pops up my timeline, and it's no other person than Fisayo Lounge, and it was the same, another brand calling out Boohoo for stealing their designs. Like, and I got onto Instagram and I saw another post. Givenchy was called out for copying a black designer leather bucket hat with upper motifs, and I was like, okay, great. Then I started researching about what this area on fashion law is, and it was interesting, guys. So without further ado, I'm just gonna get into it. I know I said that earlier, but chill, trust me, you're gonna enjoy this. You will enjoy this and thank me later. So today's topic will focus more on fast fashion, the world of serial copiers, and the interplay with intellectual property. Now, the cases that inspired this topic, I already talked about them. Hanifa, Pretty Little Things, Fisayo Longe, the Care Collection, Boohoo. So, as we know, fashion, like every other sector, interplays with intellectual property, as every fashion item is IP protected and can enjoy a multi-layered protection in the form of the name, logo, symbols for trademark, combination of line and visual appearance for design rights, your sketches for copyright, etc. Now, for someone within the fashion industry, you can't do away with intellectual property because it plays a huge and important role for your industry. Now, what is fast fashion? This is in line with sustainability, which focusing on manufacturing, marketing, and also designing a high volume of clothing at an affordable price, depending on the value and goodwill of the brand. Who doesn't love a good bargain? The fast fashion is, I'll take that again. The fast fashion is a business model based on stealing high fashion design to manufacture and sell them at low quality, low price products with unimaginable imaginable cost. My apologies to people and planet. Hmm. Now, there are always, replicating trends into lower quality material for a fair and affordable price to the consumers. This sector thrives in taking advantage of the loopholes of providing affordable clothes, and big brands are not left out in the copying industry. I'm not surprised. Are you? So if you read the tweet, I attached a picture to the this conversation, and it says, week one, the designer creates a clothing prototype inspired by the latest celebrity trends and runway looks. Week 2 to 3, over 10,000 pieces of clothing are made ready for shipment. That's a lot. Week 4, sorry, week 3, the apparel is driven to the distribution centers and flown to stores around the world. And then week 4, new items hit the store and are made available to customers. I mean, you want so you want it, and then you got it at a very cheap and affordable price. Can you beat that? Can you beat that? I guess not. Now, according to Lucy Sego, she says, fast fashion isn't free. Someone is actually paying. Thanks to social media and the internet, the reproduction of creative work is not easy because of access. Now, I will now go further to give you a list of serial fast fashion brands who have been accused of copying or making an imitation of a trend. So number one is case study for today. So if you remember last year, there was this brand that broke the internet with their 3D virtual fashion show. That was Anifa Mvemba of Hanifa. So Anifa is Anifa, while Hanifa, her brand name it starts with a H. So it's just added a H to the name. Now, this year, she is suing or accusing Pretty Little Things, a fast fashion retailer, for creating a version of her $229 Veronique blouse, which she showcased last year during the 3D virtual show for her pink label Congo line. And Pretty Little Things made theirs and sold it for $55. Now do the maths, guys. One thing you should know about Pretty Little Things. Why did I say Pretty Little Liars? No, I didn't. I did not. Okay, so Pretty Little Things are notorious for ripping off people's design. And the second brand, or the second case study, features a big brand. Givenchy, like I said, was accused of copying a black designer's leather bucket hat with motif. I came across this post on Instagram by an Instagram post by retailboss.inc. You can check them out. It said, hats off, folks. Givenchy's latest design, a leather bucket hat with a zipper motif, is apparently off the market after Bronx, New York designer K. Tyson Perez accused the luxury brand of stealing his hardware style hat design. This comes months after the accusation was first made publicly and fans started demanding design credits in at Matthew M. Williams, creative director of Givenchy. Instagram post wearing the hat design. He has yet to acknowledge K. Tyson Perez nor take down the post showing the copycat hat design. Givenchy apparently has no plans on profiting off the sales of the hat, but will not acknowledge the real creative director behind the design. And this is one of the issues that you find within the fast fashion industry. No one wants to acknowledge and say, oh, inspiration, or I copied this from XYZ brands. It's because, anyway, I'll say the reason why that happens towards the end of the recording. Now, the third brand is Fisaya Longe, who sued Boohoo for its care collection and had briefed their lawyer to send a cease and desist letter demanding that they stop selling the replicated product and demanded not three, they demanded £30,000 in damages. Go girl. I hope that turned out well for her. But in the event that, let's say, someone steals your intellectual property, reach out to your IP lawyer and they're going to do the need. They know what to do. Don't just sit down and start taking that action and then later come back to meet them asking them for solution. Well, they would provide solution, but it's gonna cost you more. But yeah, let's move on. Number 4 is Kim Kardashian, who was recently listed as a billionaire. So, the gold look from Kanye West against Misguided. So, Kardashian sued the fast fashion brand Misguided for using her name and likeness in conjunction with their brands, stating that they violated the trademark with her name by advertising their company brands. Misguided was ordered to pay Kim Kardashian $2.7 million in damages. Look, guys, one thing I really find interesting about IP is the fact that people sometimes, underrate or underestimate what the court can do for them. People just feel like, oh, the court is just going to rule in my favor, and like, I didn't really steal it, or I did not use it for commercial purpose. It was fair dealing, blah blah blah. But it shock you. It might be shocking, or you might be shocked when the court responds by saying you actually stole the IP. Now go pay some money. So be careful while you're out there. Next up is in line with our current reality, where there's a lot of social media color to mess up cancel culture comes knocking at your door. Now, this case is between Old Navy by Gap against Carrie and Roberts over the use of the phrase on the t-shirt, raising the future. Now, remember that trademark as an IP could be in form of a name, phrase, logo, sign, symbol, anything that can be linked to you. And in this case, raising the future was a catchphrase used by Carrie Ann Roberts on her merchandise. And Old Navy thought, oh, let's, make ours. And they went ahead to do that. And the internet wasn't having any of it. So Old Navy finally removed the product from their website. Not sure if any money was paid, but they were saying that Annie Robert did not trademark the phrase raising the future or the future design or the graphic, and therefore had no legal right. Like I said, like in the US and the UK, what they apply there is the first to use principle. So does this now mean that if a mark was not registered but the person has been using it consistently, a third party can reproduce it? No, especially for a jurisdiction like the US where it's first to file. Now who first to use and go get the mark? Whereas in Nigeria, if Old Navy had gone to register before Carrie Ann, that would have been heartbreaking. But yeah, you have to be proactive as an IP owner. So when I posted about this particular brand, I just said, dear Zara fans, please gather around. Zara was accused of copying Balenciaga, my Nigeria people. They were accused of copying Balenciaga's. I feel like they pronounce it well. Okay, let's forget about it and move on. But Zara was accused of copying Balenciaga's sneakers and Kanye West's converted Yeezy. And I said, please, Balenciaga, come to Nigeria and see something. I know 2019 December, we had a lot of lemon Balenciagas flying around and, cross, I don't know what to call it, multiple luxury brands on one shirt. But anyway, they were accused of copying. Zara was also accused of copying the pins from Illustrator, Tuesday Basson, and a sandal by Aurora James of Brother Village. So if you're an illustrator and someone steals your design, know that you have the option to always sue. Sue, I don't want to use the F word, but sue the person. Sue the out of the person and get your money. But you also have to, do the work in proving that there's actually a copying done. Now the next one is crazy. Two brands, Missy Empire and Nasty Girl, created a jumpsuit by Bauman. Like seriously, una get mind. Two of una just sit down, say una go copy this brand. I mean, it's actually a nice dress. They're fans of Asos. Your beloved is also guilty of copying styles from luxury brands. So you see that there's no discrimination. Both big brands, small brands, everyone is like, this is cute. Let me do something sharp, and then So that's how the fast fashion industry works. But I still have, I think, 4 more cases. So let's just run through them. So let me report myself. I had to go do a Google search to pronounce the brands Balmain and Balenciaga. So the next serial copier is Forever 21, who is accused of copying phone cases, popular feminist tees, Instagram famous swimwear, Gucci's 3400 jacket, that's $3,400 jacket, and also used their iconic trademark blue, blue and green, and red green stripe. And get mind, sha. So what Forever 21 did was that they sold their own jacket for $34.90. Ew. Anyway, the next one is the iconic Versace jungle print Barocco print dress that was copied by Fashion Nova, which Jennifer Lopez had won in 2000 at the 42nd Grammy Awards at the Staples Center in Los Angeles and California. And she also wore the dress again during the spring 2020 show during the Milan Fashion, where she modeled the dress and killed it. Anyways, Fashion Nova was accused of exploring the popularity of the dress and also trading the goodwill and business reputation of Versace for profit for profit for profit and sale. And I do agree, because they named, the funny thing was that they named their collection Love Don't, my love, no, they didn't add mine, they just said Love Don't Cost a thing. I don't know if you guys remember, but Jennifer Lopez tried to start a Love Don't Cost a Thing challenge, and it was a big flop. Anyways, Fashion Nova sold their own Love Don't Cost a Thing two-piece costume set for $69.99. And they were also accused of copying another brand. I'll be right back. I need to do something. Okay, I'm back. So Fashion Nova was also accused of copying a vintage Thierry Mugler black dress. Yay! From its spring-summer collection, Women by Kim Kardashian, for the 5th annual Hollywood Beauty Award. H&M, my babies. Anyways, H&M and Gosha Robchitsky and Vetameta, a Russian fashion designer and Parisian design collection on hoodies, t-shirts, socks over the font style. So H&M is the one that did the copy here. Sad. Then Forever 21 again against Puma over its Fenty by Rihanna collection. They sued them for design patent, trade dress, and copyright. Then you have again Forever 21 copying H&M's over the Beach Please bag. So H&M's own was beach, like the actual spelling of beach, BEACH. Then Forever 21's own was Beach Please. You get. I'm not going to spell that, so let's move on. Then you have Gucci against Guess over the use of Gucci's logo and pattern, which they won, and they were awarded $4.7 million. Did I get it right? Yes, I did. Now I could go on and on, but I'll stop right here to talk about the interplay of IP in the fast fashion industry. And as we know, IP is territorial in nature and gives the owner legal backing and protection, especially when the creative or innovative work has been registered. So, in the fast fashion industry, the principle on consent, permission, and authorization is not even considered because fast fashion brands or styles are considered to have short lifespan, and the only options for IP protection is a bit difficult since it relies solely on trend. Because by the time you go to court, you've moved from winter to another season, say autumn, spring, summer, and the rest of it. So it's more like you're just wasting your time. In a world where trends of products are quickly made and sold, one begins to wonder if really IP exists in that industry and how the IP owners can protect themselves. IP protection in this case would depend on the jurisdiction, and in the course of my research, I found out that France is said to have like a good IP framework for the fast fashion industries. Here are the IPs that are considered: copyright protection for the sketches. It protects original textile, prints, and garment design. Whereas in the US, there's no protection for clothing design, but IP owners can still, opt for a patent design by exploring a multi-layered IP protection, such as patents, if the fabric, if it has fabrics like nylon, the company's logo, name, slogan can also be trademarked. Then you also look at trade dress, which focuses on the design. The US has a law called Innovative Design Protection Act, which protects fashion dresses. Whereas in France, the copyright law provides that any original work expressed in any form can enjoy copyright protection. In Nigeria, your sketches, that's your drawing, prints, can be protected, and this was elaborated more in the interpretation section, which is section 51 of the Copyright Act. Design rights, which could be registered and unregistered with a 6 months grace. Please listen to my podcast on whether a design can be patented, when I talked about the Coming to America case against Ugo Moye, when he said his patent was being used in the Coming to America Part 2 movie. Now, design rights in the UK are protected under the UK registered design and unregistered design. However, the design must have an element of individual character. And when it comes to the use of design of fabrics affiliated to traditional knowledge and geographical indication, the infringers are most likely high street or luxury brands like Gucci, Louis Vuitton, who are accused of cultural appropriation. Cultural appropriation takes some elements of a culture, reuses it and infuses it into the fashion without any express consent, permission, and authorization from the community. For instance, in May 2019, the Nike Air Force was to be adorned with the molar patterns originating from Guna culture of Panama, Puerto Rico sneakers. It was opposed by representatives of Guna people, which led to Nike canceling the sports shoes. Then another form of IP is trademark. You can trademark your brand name, logo, signs, symbols that identifies your brand. Patent depends on the jurisdiction you find yourself. Then issues that may arise, you have design piracy, contributory infringement, where you can be held liable for an infringement even though you were not part of it directly. Then lack of IP laws that are strong enough, and then enforcements to back the fast fashion industry. You have issues around use of technology to copy, rise in counterfeit products in the market, which could be sold in retail stores via e-commerce sites or social media platforms like Instagram or Facebook. Then you have theft of creative and innovative work. In wrapping up, here are the available remedies for those within the fast fashion industries, whether they are fashion designers or illustrators. One, forget about social media call out. File a suit in court. Even though Tuesday Basson may have used that method and Carrie may have used that method, um, Zara was criticized and forced to remove the infringing items from his shelf. But social media call out is not always the way out. Do the needful, talk to your IP lawyer. They know what to do. They'll advise you properly on what to do. Pay. Pay for consultation too. Third party retailers takedown processes, which is done by reporting the infringing item online or websites, can be taken down. For instance, Amazon, eBay. I don't think we have that yet in Nigeria, where Jumia can take down products for because it was infringing another person's work. Then, then opt for a cease and desist letter, like Visa Lounge Longate did, discontinue and destroy the goods, file a suit as a community like the Guna and Masia tribe through your representative to preserve traditional knowledge and prohibit cultural appropriation. I also made mention of the Masia case where they finally got to reclaim their brand. So yeah. So here's the interesting part. Because we're turning 1 year on the 18th, I will be doing a giveaway at 12 p.m. 18th May. One will be on Twitter, one will be on Instagram, and one will be on LinkedIn. That means you have to be following or IP series page or my personal page. Now that's your job to figure out which of the platform I'm going to use. So it's hashtag IP series and Rita and Richinda. Yay! And so we've come to the conclusion of this particular episode. I hope to see you guys on the 18th, and I hope you also learned something from this particular episode. If you did, don't forget to send me a voice note on Anchor or send me a DM on Twitter or Instagram. And please follow hashtag IP series with Reader. Reader is spelled REEDAH on LinkedIn. So until the next IP series episode, have a fab week, guys. Bye.